Welcome to our podcast series, 5 Questions, 5 Answers, in which we explore recent U.S. trade policies and U.S. trade rules that can affect thousands of companies. We have a goal in mind to help you, the listener, translate the legal into real-world business strategies. My name is Birgit Matthiesen. I'm the Director of North American Manufacturing here at Aaron Fox Schiff in Washington, D.C. I get the easy part. I get to ask the questions, and I get to choose the colleague or the guest I know will have the right answers for you. So in the next few minutes, I will ask 5 questions that reflect the concerns we've been hearing from business leaders, all who want to understand the rules, but they also need to mitigate their business risk while increasing their bottom line. So let's start. These are indeed uncertain times. They must be very uncertain times for very anxious company executives trying to navigate this whirlwind of tariffs, tariff calculations, free trade agreements, and enforcement. There have been numerous new tariffs being announced. Many are bilateral with very specific trading partners. Others have been regional. The rules to take benefit from these free trade agreements differ. So it's a world of risk. And today, I'd like to talk about this notion that has been called enterprise risk. Traditionally, companies facing risk have approached it in many instances in a stovepipe fashion. Today's world, of course, requires a holistic approach, especially when it comes to the calculation and the payment and the exposure to these now double-digit tariffs. That's where the term enterprise risk comes from. It is an analysis and identification and strategy to mitigate the risk to the whole company, to the whole strategy. We have today a guest from our firm, a partner here at Aaron Fox Schiff, Tony Rivera, and he comes to us and to this conversation with his insight gained from many years as a senior counsel to U.S. Customs and Border Protection, and now with Aaron Fox Schiff. I thought that with everything that is whirling around us, a catch-up with Tony is exactly what we might all need right now. Tony Rivera, welcome back to our podcast.
Thank you, Bridget. It's been a little while since I've been on with you. I'm happy to be here today and talking about uh, enterprise risks and the various different developments that have been affecting the trade industry in this little over a year now since a lot of these tariffs started.
Yeah, and I happen to know because I work with you that you've been a very, very, very busy person. And so, on behalf of our listeners and myself, thank you for taking the time once again today. I did want to talk about risk enterprise. I've heard this phrase pop up every once in a while. I understand that. Risk enterprise is not a new notion, but we are now entering a new era of risk and especially with these U.S. tariffs. So let's just begin, Tony, by making something very clear by asking you this question. Tariff risks, the payment, the exposure to these new U.S. tariffs, it's more than a bottom line increase in costs, right? It's not just a revenue risk. It is more. Can you, A, do you agree? And 2, can you elaborate?
No, certainly that's a very important question. I think it's really reflective of the moving landscape and the U.S. government's reliance on tariffs, really since before the Trump administration, but now even more clearly in this administration, the use of tariffs for various different measures. And I note this, starting before the Trump administration, because there has been bilateral support for the use of tariffs, right? There was the first Trump administration, the increase of Section 301 and 232 tariffs, the continuance of those tariffs through the Biden administration, and now a whole host of other more significant tariffs. Um, but yeah, you're absolutely correct, Bridget. It's more than just a revenue cost issue at this point. Right now, the number of tariff regimes that have been announced since last February, um, that's definitely. I think it's 12, 15 over the last few years, but there's even more, and plus the investigations that have been ongoing. But all of those regimes that have been issued have different and complex trade rules. And the issue with having different and complex trade and customs rules is that it leads to many instances where a rule isn't very clearly interpretable. It leads to doubt and uncertainty into how to apply those type of rules. Um, and therefore, when an importer has to make a decision as to how to uh, enter its imports into the United States based on the various rules that are generally applicable: classification, value, country of origin. They also have to now interpret these other tariff regimes and the rules related to those tariff regimes. And if they're incorrect to any degree, they're subject to potential penalties and other administrative enforcement actions that CBP can take. And the penalties can be steep, and the enforcement measures can be long and very administratively expensive, because CBP has, number one, they have a 5-year statute of limitation from the point of entry to 5 years afterwards to enforce and ask questions about uh, import practices that came in. But also, when you for each one of those imports, and each one of those imports has its own 5-year statute of limitation, um, to the extent reasonable care wasn't exercised with those imports, um, meaning there was a level of negligence or higher, the penalty amount is not just the duty owed from the difference in duty amount, but it's at least 2 times the duty loss of revenue to the government, but it can go up to 8 times or the value of the good itself, which is a penalty amount on top of the duty exposure. And back to the interpretation part of this, the rules are not clear in many cases. There's uncertainty. So there's a risk element in just making a decision as to what rule you're going to apply. Do you apply a rule with consideration of some risk points in applying that rule for the tariff benefit by making that interpretation on that interpretation? Um, are you protecting yourself from duty exposure, or are you protecting yourself from penalty exposure? Those are two different uh, elements and targets, really, that need to be considered in that type of assessment. So it really becomes a very complex calculus, if you will, navigating between these different trade programs, tariff regimes, and the different traditional rules that are already in place for customs and imports, which requires a lot more time and a lot more focus to determine, you know, what can you save, but also what risk exposures do you have by not taking the potential measures, which can very quickly lead to yeah, significant amounts of money and time just in protecting the company, and also could be reputational issues too in terms of um, the type of enforcement action taken, or even if it gets into litigatory actions as well. So a lot of different considerations that now need to be taken when acting as an importer into the United States and being subject to these various different rules and programs.
That's right. And to broaden that conversation just for a moment in terms of enterprise risk, Tony, um, if if a company is importing components, critical minerals, assemblies from abroad, the tariff is triggered by, for the most part, the country of origin. And all of a sudden, the risk to the US based company is if there's a double digit tariff to my inputs, then my supplier base needs to be reviewed, perhaps. Are we buying from the right countries or the right regions? Do we need to change our contractual obligations and agreements with our suppliers? If the tariffs are double digit, it would not only increase the production costs in the United States, which is where the CFOs are getting anxious, but your point about penalties and enforcement, all of a sudden it becomes a legal regulatory issue for company executives. And then, of course, down the line, uh, your US customers who are buying your products are probably quite aware that there are double digits on that product. And the marketing approach to the customers will have to be taken into consideration, and maybe a new review of how to approach customers who are buying your products. So I agree, it's a whole of enterprise approach and review. And traditionally, Tony, it's generally been the customs import division of a company that has been responsible for tariffs. I'm assuming, just based on your comments, that um, that might be in need of a rethink.
Yes, no, that's a very true point. What's interesting about it is customs has always been a cross-functional coordination. It's just so that the magnification of the tariff rules, the tariff regimes, and the impacts that it's having on companies is making that cross-functional coordination very critical, moving to multiple different departments and multiple different effects. As you noted, Bridget, in your points, the supply chain elements of this will definitely have impacts and considerations to procurement departments as well as sales and marketing departments in terms of the product being imported and those type of relationships. But even if you're looking at the types of rules that need to be reviewed and considered for um, duty exposure, risk exposure, penalty exposure, just kind of just considering those three elements. Um, that requires uh, accounting, it requires finances, it requires your engineering team for the specifications of your product. Um, it requires research and development for understanding how the product was developed to understand the particular product classification and elements of it. Also, the supply chain production for country of origin issues and for free trade agreement issues. Again, the valuation part, and that's why you need finance and accounting because that'll inform how much you're actually reporting to the government for the assessment of the tariff, or it could also impact one of the free trade agreement qualifications. All of those elements are interlinked into different traditional customs rules that are always used at entries. And again, I'll repeat it again because it's important to understand these concepts to then translate them to how it's affecting the tariff regimes and tariff programs. But with imports, you have um, with every good that's imported, it has a classification that's a product type. It's a code essentially that defines what that type of product is. That assigns a most favored nation duty rate. Um, you report the country of origin in relation to that product for that code. Um, and you report the value that the importer pays for that product. That's traditional Customs 101, three elements that are always reported to customs on products. Um, with tariff regimes and these new tariffs, uh, they utilize those elements and they assign additional tariffs in relation to country of origin or in relation to uh, your uh, your tariff classification, that particular tariff code, and it'll assign either double digit tariffs or potential exemptions to those tariffs. So now coming back to what's going on this year in kind of this type of review, these type of assessments, these type of questions. Um, before this time period, complicated, still needed the four. It still needed the traditional elements in this review, and it still needed these teams. But now you have a very complicated mess of a review with an import documentation, where you really first you need to trace through these different elements of the customs information, and then you need to talk to somebody in engineering to understand, did we report the right classification? Was that the product we specifically tried to import? You have to talk to finance to know, did we report the right value? Is there any way we can reduce the value so we can save on tariffs? Uh, Procurement and also sales will be involved for the country of origin requirement reportings that are required on these entries, which are now going to be reported on different lines because there's different elements that you're reporting to either mitigate or comply with tariff measures that are being added on top of it. So if you don't have those departments coordinating together, first it becomes very difficult to provide the right information at the time of entry, which is a legal liability in itself. But it also makes it very difficult to be very strategic about what you're reporting, what risk levels you're utilizing, and how to be prepared for responding to CBP and taking careful and measured approaches that work under the reasonable care spectrum. Because what's really important here is there's there's uncertainty, there's risk, there's a lot of rules. That's gonna be constant, and it's gonna be constant for an extended period of time given the 5-year statute of limitation. But customs has a reasonable care standard. Reasonable care means the importer, uh, eh, utilized, legal counsel, reviewed the appropriate, legal standards, and has the appropriate documentation to support a claim at the time of entry. So even if CBP disagrees with that claim at some point down the line, the fact that the importer acted with reasonable care is a protection against the penalty portion. So CBP disagreeing means potential loss of revenue in terms of uh, the duty amount saved by making a decision, but what it protects you from is the penalty part, which is really the significant monetary exposure, which is at least 2 times the loss of revenue. So suppose you have an import where you paid 10,000 in duties, but the customs disagrees, and you owed 100,000 in duties. That's a $90,000 loss of revenue. If you're protected by reasonable care, that's all it is. It's a 90,000 that you would owe for that decision point. If you did not act with reasonable care, it's 2 times the loss of revenue plus the loss of revenue. So that's 270,000 at the baseline, and that goes up all the way to the market value of, the value of the product as declared. So there's significant monetary exposure, and when you're talking about those type of actions, penalty actions, there could be reputable harm that could require communication with suppliers and customers in terms of, um, correcting and addressing issues in that supply chain. So it can become a very complicated issue to resolve, at a much broader level once you are in that penalty and enforcement stage. But if you have reasonable care and you've acted with sound advice, sound documentation, you have a competitive advantage in making uh, strategic and important decisions for your company in a way that insulates you from that type of significant exposure.
and uh, demonstrating reasonable care also promotes the confidence level from a company's investments and investor communities and shareholders and board of directors, to say the least, I can imagine. But before I ask you my final question, which is, and get ready, Tony, my final question is going to be, so how do we help? Uh, Let me ask you what the latest is on two tariff-related actions. One, which everyone is watching for, is what is customs and when is the administration going to actually refund IEPA tariffs to comply with the Supreme Court decision. And if you can, Tony, can you touch on the very latest that you're hearing on the US 232 tariffs on steel and aluminum?
Mhm. Yeah, no, those are 2, actually, very, relevant topics of today even 'cause there's been announcements, today on the 232 on the potential 232 proclamation issuance, but also there's been updates in the CBP process for, the IEPA tariff refund. So, I'll start with the tariff refunds first just, to, there's been, I guess, more information on that part of the process. Um, and, as many of us know at this point that the Supreme Court already issued the decision invalidating the IEPA tariffs that had been affecting, uh, the significant majority of all imports since, last, February, 2025. And now it's the Court of International Trade and CBP administrative process that is working to um, create a system for returning those IEPA tariff amounts to importers. It's a relatively um, complicated system, and as we're talking about cross functional coordination between departments to understand how to start utilizing the system or how to prepare the system. I mean, this falls right in that because we're talking about, in many cases, millions of dollars of IEPA tariffs that are owed in refunds to the company, and figuring out the timeline for for those refunds and the mechanisms to utilize for those refunds, and risk points in relation to those refunds requires this type of cross coordination to understand what those risk points are. So right now, CBP is creating this process called CAPE uh, within the ACE CBP ACE environment. It's the CBP import database, which will create this module, this CAPE module, to facilitate the the refund claims. Now, that process is still not functional. It likely won't be functional until about April 20th. It has a prerequisite where importers that'll be relying on the K process need to have electronic ACH enrollment with CBP. So that's a prerequisite, and importers can start on that part of the process. But once the Cape module phase one becomes functional, importers will be able to uh, make declarations into the CBP system, informing CBP that a certain amount of entries is each import, the imports that had an IEPA claim or IEPA tariff paid on it are eligible for uh, this refund process through CAPE. Working through that, there's various parameters right now where more or less um, only certain entries will be processed through the phase one part of this CAPE refund process. That's going to require identifying the imports beforehand that meet the right timing parameters, that do not have certain trade programs attached to them, like drawback or value, free trade agreement, or classification reconciliation programs, um, uh, and certain liquidation date issues. If imports have that type of information in their import profile, they're not gonna be processed through phase 1 of the CAPE module at this time, and importers will have to wait until subsequent phases or other CBP mechanisms to obtain that refund amount. Um, Identifying the timelines, within what's eligible for CAPE, as well as, the programs that might restrict you from the first access of CAPE, it's gonna require looking at the import information, the trade programs involved, which again, classification exercise, value exercise, country award exercise in many cases. That's going to be important to that setup, and then planning it out efficiently and having expectations as to when the refund will come and what mechanism will occur. That'll be important to track because that's a lot of what's still unknown. We'll know Cape deployment around April 20th, and then some entries will be processed after that deployment, but then there's still a lot left to come and a lot of refund amounts still outstanding. And be important to understand the risks in those secondary portions because there's definitely protest type actions that importers can take to preserve their ability to eventually get a refund through this process. So that's more information likely to come on that on April 14th, and then expect deployment around April 20th. So after that, the process will actually initiate with some uh, technical updates to come before that deployment starts, and likely as the deployment starting. Um, the other significant update is with respect to 232 steel and aluminum. What we understand is that um, the president will be issuing a proclamation at some point in the afternoon today on April 2nd, that will potentially be changing the tariff rates applicable to steel and aluminum products. And this is in relation to a very complex issue that's been impacting the um, the steel and aluminum and really products that use steel and aluminum this last year since March of 2025, um, because within this trade program, there's been a value content exemption. Essentially, uh, in the initiation of this this tariff program in last March, um, th- there was an allowance that importers could break out the steel and aluminum content of the imported product versus the non-steel and aluminum content in that product. So suppose um, you're importing a vehicle in the United States, right? There's steel and aluminum pieces in that vehicle, and there are, um, you know, uh, plastic components, rubber components, textile components, etc. There's pieces that are non-steel and aluminum in that vehicle. The 232 um, breakout that would be allowed is valuing the steel versus valuing the non-steel uh, components within that product. The concept of valuing them and valuing something uh, within the total value of an imported product has been a very ambiguous issue since the rule came out last March. Neither CVP or Commerce has provided um, detailed guidance on how to value those input points, meaning there's uncertainty and interpretation gaps in terms of how to value that product. And more or less, if you can reduce the value of your steel and aluminum content through a reasonable value interpretation, there's a significant benefit to those companies by utilizing the applicable standards. But again, it's one of those things you need to exercise reasonable care to make that interpretation. Do you protect yourself from the potential penalties involved, given that the tariff is so high? It's a 50% tariff in most of these instances. So you're really you're reducing the steel and aluminum content through a value uh, exercise. But if customs disagrees, and if you have not exercised reasonable care in terms of what you're reporting, That can be very significant penalties on top of that 50% exposure uh, that starts for those tariffs. The proclamation from today is, as we understand, looking to address that specific value interpretation. But how exactly it'll change that interpretation is still uh, there's a lot more that we'll need to examine to understand that. I mean, potentially it could be a very straightforward 25% for these goods, 50% for these goods, like 25% for steel and aluminum articles versus 50% for um, so the other way around, 25% for steel and aluminum derivatives and 50% for steel and aluminum articles. That could be a categorization type of split on the tariff rate that wouldn't be dependent on value. That's assuming, they take it in a particular direction. The scope of what those definitions are will be important to look at because that'll change what the rate is for a particular type of product. That'll look into classification type issues that we discussed earlier. There's also going to be a timing question. If a type of rule is issued, what's the effective date of that rule, and how does that apply to all of the interpretations that have been ongoing since March 2025? And to put one more element on top of that, the value interpretation is in litigation right now in the express fastener case, because importers have had to make make decision points on these imports dating back uh, since since last March, and there's been challenges from CBP for certain types of commodities. So there's the enforcement part, there's the litigation part too, and it's definitely a high profile issue now, given the amount of tariff and duty at stake, with moving timelines now, with new potential rules coming into place today.
Tony, I've had the benefit and the privilege of watching you in action. I've seen you in boardrooms. I've listened to you, how you present these issues, company specific, product specific, supply specific. And I've listened to executives ask you the right questions for which you have always the answers. And I so appreciate your taking the time with us today. Um, Tony Rivera, if you have not spoken to him earlier, or if you have not gone to his website, you may want to do that right now. His He can be reached at the law firm's website. You can just simply Google Antonio Rivera at Aaron Fox Schiff. Um, and you will see his background. You will see that his practices include international trade and investment, but also customs import compliance, mobility and advanced technology groups, and of course, the very popular website that he contributes to called Navigating Trump's Tariffs. Tony, I'm going to give you the last word. In your experience and knowing what you know and looking ahead to the end of 2026, um, what what would you say would be the best approach, apart from calling you, of course, that companies should take in the very near term?
Um, so I think the best approach is really looking at the tariff impact as strategically as possible, and I use that with emphasis because it requires this organization of the information that's it's complex information. That's why it requires organization and planning. It requires looking at that comprehensively and seeing duty exposure, penalty exposure, risk exposure, reputational exposure, and really looking at that holistically to make decision points, not just for the immediate, not for the immediate tariff mitigation that can occur from the decision on one entry. It needs to be looked at going into the future, and what that decision means for revenue streams and potential liabilities too, and also competition in the market in the next 5 years. I think that approach, and I mean that type of an organization, it can be done, you know, with uh, with the right team in place, with the right coordinations in place. It's nothing that's done overnight because it is a lot of information that requires really considerable planning and strategic assessments. But it is something that should be undertaken for companies to position themselves in a way that will limit these significant exposures and also put them in a position that they can confidently exercise business decisions without having to, you know, taking away the uncertainty of will a penalty apply, will not a penalty apply, is a significant relief to a business decision that needs to be made. And I think that's a relevant point that needs to be thought through in terms of uh, uh, these type of activities by importers.
Tony Rivera, thank you very, very much for the time. And thank you to our listeners on this podcast. As always, stay tuned for more on this topic and for many other trade related topics on our website at Aaron Fox Schiff. And we hope that this has been enlightening to you and at the very least, reducing the panic level. It's all about knowing what you know and identifying what you don't know. Thank you again to all our listeners.